Hello, my name is Michael Tesoro and I prepared this free competition law training course for small business. And the reason I prepared this is because there seemed to be an increasing incidence of small businesses getting taken to court by the ACCC for competition law breaches. And there's a strong need for the small businesses to have an understanding of the relevant laws so they can avoid contravening them. There's also been a number of small businesses taken to court, and there's often a requirement as part of the settlement that they undertake competition law training. So this course will hopefully be the course that those people can do in order to satisfy that obligation. Now, with this particular training session, there are actually quite a lot of links to various resources, but because I'm doing a video, those links won't work. So what I'll seek to do is put a copy of the PowerPoint presentation with all the active links on my blog, so that if anybody wants to access the PowerPoint and hit the links and go to the resources, they'll be able to do that. Alternatively, you could just email me and I could send you a copy of the PowerPoint. A bit of background about myself. I'm a competition and consumer lawyer. I've been running my own practice, Tesoro Legal Consulting, for the last 14 years, and I help companies, individuals with ACCC investigations and litigation. I also do a lot of work in independent reviewing and independent auditing, and that relates to companies who have to bring in a compliance program, and I'm retained to come in and assess the effectiveness of the compliance program and determine whether it meets best practice. So I've done that for quite a number of companies, for example, Aldi, Airbnb, Baby Bunting, Dell Computers, and so on. I also do independent auditing of divestitures mandated by the ACCC. I've done the bingo dial-a-dump divestiture. Also do some auditing in the product safety area. I was the independent auditor of the McLaren automotive Takata airbag recall. And I also have companies with compliance programs, developing those and implementing those. Prior to that, I worked at the ACCC for 15 years in a variety of director roles. My last role was as Director of Enforcement in Sydney. I also was the Director in charge of the Sydney Mergers and Asset Sales branch for a few years, and also did a stint as a National GST Enforcement Coordinator. And over the last 15 years when I was there at the ACCC, my teams did about 500 investigations, 100 merger clearances, and we ran 30 plus court cases. So I have quite a lot of experience both at the ACCC and private practice, which I'll hope to bring to bear on this presentation. Now, that line of the training, I'll start with introduction and background, then look at the ACCC priorities, which is a very important thing for small businesses to be aware of, then go through the various sections, and they can be broken up into two categories, I guess. 45 is the one that most small businesses are likely to get in trouble for, most likely to get in trouble for, because that includes cartel provisions. With the rest of the provisions, small businesses are likely to be a victim to conduct being engaged in by bigger companies or larger competitors. So it's important for small business to understand those sections so that they can understand their legal rights. Then I'll look at the ACCC powers and remedies, and obviously given its presentation I can't answer questions, but if people have questions they can just leave a question on my YouTube site, or alternatively send me an email. Now, the purpose of the training is to provide you with sufficient knowledge of the competition law provisions of the Competition and Consumer Act to do three things. Firstly, to identify conduct which may breach those provisions, then to work out solutions to remedy potential problems, and finally to implement strategies to avoid the risk of breaching the CCA. Now, clearly identifying conduct is in two categories. Firstly, to ensure you know what the law says so you don't breach it, and also to know when you might be a victim of illegal behaviour and know what you can do in response to that. And as far as strategies go to avoid breaching the legislation, clearly having some sort of compliance program in place is the best solution, but probably not the type of compliance program that the large companies I mentioned before would implement. Rather, probably a basic model, which would be a compliance policy and some training for staff as to what they should and shouldn't do in their roles. Now, a good place to start is to look at the objects of the Competition and Consumer Act. So as you can see, there are three objects, and these are the same objects for the Australian consumer law. And the first is to promote competition, which obviously makes sense, but that isn't the only purpose of the Competition and Consumer Act. It is also to promote fair trading. So there is an element of ensuring that businesses trade with each other fairly, and that's clearly that big businesses have an obligation to trade fairly with smaller businesses. That's reflected by Section 46, which is a misuse of market power provision, and also by provisions of the Australian consumer laws such as unconscionable conduct and unfair contract term laws. And finally, there's an object of ensuring that consumers are protected both from misleading and unfair conduct as well as anti-competitive conduct. Now, the relevant provisions are set out in Part 4 of the legislation, and they start with cartel conduct. And as you can see, there's a lot of sections there that cover this particular conduct, 45AA all the way through to 45AU. The first really relevant provision is 45AD, which defines what a cartel provision is. And unfortunately, that section is about 1,800 words long. So as you can imagine, it's very complex and convoluted and really difficult to understand. So I won't go through that in a great lot of detail. I'll try and provide an overview of what the legislation says so you understand what it means. Then there's 45AF and AG, and they're the criminal offences of entering into a contract arrangement or understanding which contains cartel provision. And these are the two offences which have a maximum penalty for individuals of up to 10 years imprisonment. So they're very serious offences. And as you can see, there's the offence for making a contract which has cartel provision and also giving effect to that agreement. So even if you make an agreement and never put it into effect, you could have committed a criminal offence. Clearly, if you've made the agreement and put it into effect, you've committed two offences. Then 45AJ and AG are effectively the same provisions, but they're civil prohibitions. So you can't go to jail for those two particular provisions. And the way that's supposed to work is ACCC is supposed to focus on a criminal prosecution where they believe the cartel is a hardcore cartel, and where it isn't a hardcore cartel, they should look at a civil prohibition. But that's the theory, and I'm not too sure it actually plays out in practice. I think it's a bit rubbery, that idea. Now, there are quite a few exceptions to the cartel laws, and these don't have a great level of application to small business. Obviously, if you notify the ACCC of particular conduct and the ACCC approves it, then you can't be prosecuted. But there are other types of exception which really don't apply to small business very much, joint venture exceptions. Then there's what they call anti-overlap provisions. So if there's some resale price maintenance or exclusive dealing conduct, that can't be a breach of both those provisions and the cartel provision. And some of the other ones there, dual listed company arrangements, are not very relevant to small business, and acquisition of share or assets, again, not very relevant. Probably the last one could be the one that's most relevant to small business, where there's a collective acquisition of goods or services by parties to a contract arrangement understanding, and also there's a collective bargaining arrangement in place. So there's limited exceptions for small businesses. Then the rest of the provisions are set out in 45 to 50, and as you can see there, contracts, arrangements and understandings that lessen competition, misuse of market power, exclusive dealing, RPM, and then mergers and acquisitions. There's also provisions prohibiting boycotts by unions or entering into agreements with unions to boycott a particular company, and I'll go through those in a little bit of detail later on, but there are provisions where small business may also be a victim. Now, the ACCC is a Commonwealth agency which has exclusive jurisdiction over the competition law provisions of the Act, so it doesn't share that jurisdiction with any other regulator. That is different to the Australian consumer law, which is actually a shared jurisdiction with a number of state and territory regulators. ACCC also has other jurisdiction in relation to telecommunications, monopoly infrastructure, and it seems that every year they're given more and more jurisdiction to cover a wider range of areas, and that's because they're a very effective and successful regulator. Now, dealing with ACCC, you'll realise that they're very professional in the way they do things. They hire the best people and they approach their investigations and litigation in a very professional manner. They also are very aggressive. They don't really hold back in terms of their investigation. They'll serve Section 155 notices, which are like subpoenas asking for a huge amount of information, and they will run the litigation very aggressively, hiring very experienced lawyers, senior counsel, and they throw a lot of money at their investigations and litigation. They don't cut corners. So that's what to expect if they do come after your company. Some good news for small business is that ACCC does tend to focus on bigger targets rather than small business, and just over the last few years they've taken legal proceedings against Google, against Telstra. They got $50 million out of Telstra for unconscionable conduct. Colgate, Coles, Apple, Reebok, Arnott's, Volkswagen, they got $125 million out of Volkswagen for the Dieselgate case. Woolworths, I think they've sued Woolworths at least 12 times. Ford, Holden, Pfizer, ANZ Bank, Citibank and Deutsche Bank were the three banks involved in that ill-fated cartel prosecution, which folded earlier this year. Macquarie Bank, LG Electronics and Ramsay Health. And just in the last 12 months, these are the cases that the ACCC has taken. Firstly, they took a case against Facebook for alleged crypto scams. They also were successful in the Mazda case about consumer guarantees, took action against Uber and Airbnb, took a contempt action against Ultratune, and they've also achieved in the last 12 months significant penalties against a number of companies. So Google $60 million for the location data case, Trivago $44.7 million in relation to charging for the privilege of being ranked higher than other hotels, Samsung for its waterproof phone case $14 million, Mercedes $12.5 million for downplaying the seriousness of the Takata airbag recall, and finally Peter's Ice Cream $12 million for exclusive dealing. And there's just some of the results. And what you can see is the ACCC has been getting bigger and bigger penalties from the courts over the last few years, and that trend is set to continue. Now, when you're looking at the Competition and Consumer Act, you have to understand that you can be liable as a primary contravener or as an accessory. So clearly, if you're a primary contravener, you're the business or the person who has engaged in illegal conduct. You've made a misrepresentation, or you've engaged in some other illegal conduct such as a price fix or a bid rig, and so you can be sued as a primary contravener. The other way you could be sued as an accessory. So this might be an individual, a director, a manager of a business who has assisted or was knowingly or recklessly concerned in the contravention. Now, most individuals are sued as accessories. The thing to realise here is that whilst a primary contravener, the onus of proof is actually lower for a primary contravener. A lot of the offences and contraventions under the Act require it to be shown that there's a purpose or an effect of particular conduct. The only exception is criminal cartels, where you have to prove mental element, knowledge and belief of the illegality of the conduct. But with an accessory, it's actually also a higher onus of proof. It has to prove a mental element, that individual was knowingly involved in conduct or was reckless as to whether the conduct was problematic. So just to remember that the onus of proof for accessories, who are often individuals, is higher than for a primary contravener. Effectively, it's harder to get a successful result against an accessory than it is against a primary contravener. Also, the legislation extends to the directors, employees and agents of the company. So if a director or employee or agent engages in particular conduct, then the company can be held liable. And what the ACCC has to prove for that to occur is that the direct employee or agent engaged in the prohibited conduct, and also they're acting within the scope of their actual apparent authority. Now, clearly the main thing there is how do you prove what was their actual apparent authority, and probably one important thing to have in place is some position descriptions which specify what each employee's role is in the business. It's very worthwhile to have that, so that if there's some conduct by an employee outside what their authority is, then potentially you may be able to avoid liability for what the employee's done. Now, it is interesting the way that you have these civil and criminal prohibitions next to each other. So the CCA creates both civil and criminal contraventions for cartel conduct, but the only criminal offences under the CCA are for cartel conduct and obstruction offences. So lying to the ACCC, destroying documents, preventing maybe the ACCC from executing a search warrant. So they're the only two things that anybody can go to jail for, and that's important to remember that there's aren't other conduct in the Competition and Consumer Act which can result in imprisonment. Another interesting thing is that criminal prosecutions in the competition law area have increased pretty significantly over the last few years, both in terms of criminal cartels as well as obstruction. And on the Australian consumer law side, where criminal penalties have been available, although not imprisonment, been available for a long time, there seem to be less and less cases being run by the ACCC. Now, as I said at the earlier on, it's really important for small business to understand the ACCC's enforcement priorities. So what they do is every year they put out this series of priorities, and that guides the agency as to what they're going to be looking at in the coming 12 months. So it's really important for small business to be aware of what this says, to go through it and see if they're the types of conduct which the ACCC will be looking at, to make sure they aren't in the firing line. Now, as you can see, this is actually from 2022 to 2023. So what the ACCC decided to do this year was to align the priorities with their annual report, which goes to Parliament. So these particular priorities will be in place for a longer period until June 2023, and then there'll be an annual release of these priorities. Now, Sims was the chairman when they were released, and he has subsequently stepped down from the role, and Jenny Cass-Godlieb has taken over, and she's endorsed these particular priorities. Now, the ACCC, as said earlier, follows these priorities very scrupulously, so it is a very good guide as to what they're going to be focusing their resources on in the next 12 months, in this case, the next 18 months. There's also a video that I did there going through the ACCC priorities in much more detail, so if you're interested in getting a better understanding of that, feel free to watch that video. Now, the reason the ACCC have priorities is because they get so many complaints and inquiries, and as you can see, last financial year they received 396,000 complaints. Now, in their annual report, they had this very helpful litigation funnel diagram which just shows you how they process all these complaints, and it starts off with an assessment of 254 matters. So they're the matters that pass through the rigorous assessment process, and the ACCC decides to do some more work. That might be doing some further research and checking out whether there are other complaints about the particular company in the database. And once they've done the initial assessment, it's culled down to 157 cases where they commence an initial investigation. Now, the initial investigation involves writing to the company complained about and asking them for information and documents and an explanation of their conduct. So only 157 cases are subject to initial investigation. That's culled down to 68 cases where they do an in-depth investigation. And that's probably the stage at which the relevant investigators report to the commissioners about the case and get the approval to continue investigating the matter, and often expending resources on the case. So it might be that the investigator asks for a budget of usually quite a bit of money in order to progress the investigation, and that may be money to issue statutory notices on the company to seek information and documents. It may be to require oral examinations of employees. It may also be to retain an external law firm to provide legal assistance on the case. So 68 cases get to in-depth investigation stage every year, and then 15 cases will result in litigation. That's the whole story, because ACCC resolves cases in more ways than litigation. They also enter into what are called 87B undertakings, which is a court enforceable undertaking, and that's a remedy short of litigation. As you can see, last financial year they entered into 14 of those. And under the Australian consumer law, they can also issue infringement notices like a speeding fine, which just can be paid by the company to resolve the concern. So as you can see, when you add those up, that's 49 formal resolutions in the last financial year out of 68 in-depth investigations. So that's a very high conversion rate, really, 72%. So I think that shows that the ACCC is very good at selecting cases which really will result in an outcome. But it also says that if you're a small business and you're at that in-depth investigation phase, there's a 72% chance that you're going to be either sued or be required to provide a formal outcome for the ACCC. Now, the enforcement priorities look at a range of different factors when cases are being selected. Clearly, they look at issues of significant public interest or concern. That's often things that are in the media, which are generating quite a lot of discussion, particularly social media nowadays. Also look at conduct that results in substantial consumer or small business detriment. So that's reassuring for small business that the ACCC will prioritise cases where small businesses are being harmed. Also, they tend to focus on national conduct by large traders, and that's for two reasons. Firstly, there's a recognition that conduct by large traders is likely to cause a lot more consumer detriment in the market. So if you were to take action against them, you'd be reducing that level of detriment. But also there is a tendency for the conduct of large companies to influence the behaviour of smaller players in the market who copy the bad conduct of the larger players. So if you jump on the conduct by the large traders, you stop, I guess, copycat conduct by smaller traders, including small business. Also, they're very focused on significant new or emerging market issues. This might be something brought about by legislative change, technology, digital platforms, for example. So anything that's sort of new and trending would be something that would get the ACCC's attention. And finally, they'll run test cases to clarify aspects of the law. Now, what's on the ACCC's 2022-2023 hit list? Well, it starts off with environmental claims and sustainability. That's one area where the ACCC's been doing a lot of work. It had a big internet sweep the other day to identify problematic websites. So clearly small businesses have to be alert to that initiative by the ACCC and make sure they aren't making false or misleading environmental or sustainability claims. The next one relates to consumer and fair trading issues in relation to the digital economy, and this is some of the manipulative practices that the ACCC is concerned that the digital platforms use. And this is one that, if new laws are introduced to counter this particular conduct, is going to have some benefits for small business who are often the victims of such manipulative or deceptive conduct. Also, there's some residual issues around the place with COVID-19, which the ACCC will finish up. Then there's also concerns about the provision of essential services in energy and telecommunications. And again, this is poor selling practices which impact both consumers and small businesses regularly. There's also concerns about the way that motor vehicle manufacturers and caravan manufacturers often don't comply with their consumer guarantee obligations, which is to actually refund the consumer for a vehicle that is not of acceptable quality. Rather, they seek to repair it time and time again. And the next one is competition and consumer issues related to digital platforms. So that's separate to the earlier one, which is focusing on deceptive practices. This is really other types of anti-competitive and consumer issues arising through the digital platform area. And there's a report going to the government soon recommending a range of new powers that the ACCC thinks it needs to combat that particular problem. Then there's also an investigation, which is a joint international investigation into global and domestic supply chains. There's a concern here that a lot of the price hikes that have occurred in global and domestic transportation and the prices of 40-foot containers and so on may be due not so much to COVID, but due to some collusion. So that's an issue that's being looked at. And as a small business operator, you probably have experienced a lot of the increased costs associated with importing products. Then there's looking at the financial services sector, particularly payment services. And it's concerned that some large companies are seeking to interfere with reforms in this particular sector to lower payment service charges. And clearly this is something that benefits small business. If consumers can minimise the costs of using payment services, that's a benefit to their businesses. And also they're looking at exclusive arrangements by firms with market power that impact competition. Again, they're looking at arrangements which might prevent the supply of goods or services or the acquisition of goods or services through exclusive arrangements. And again, there's a big impact here on small business because they're often the victims of this conduct in the sense that they can't get access to products that they want to sell in their stores. There's also specifically a priority about small business getting the benefit of codes of conduct, specifically agriculture and franchising. So the two agriculture codes of conduct are the horticulture code and the dairy code. So clearly those benefit a lot of small businesses, and just generally franchising. So that obviously benefits a large number of small businesses around the country. So it's good to see that that's a priority. Also the button battery safety standard, which is a new standard, and that's something that small businesses have to be aware of, small retailers, making sure that the products they're selling comply with that new standard. Then finally there was this new one thrown in there that was a little bit undefined, and it was related to consumer product safety for young children. So there I think the ACCC is probably going to be looking at products available to young children and making sure they're safe. So again, if you're a retailer selling those products, you've got to be alert to the fact that this could be an area of activity in the next few months. And then they have these things called enduring priorities, and these are things that are always priorities regardless of the year that the priorities are put out. So obviously the first one is cartel conduct, which is both criminal and civil cartel conduct. Anti-competitive conduct is an enduring priority. Product safety is a very important priority, one with ACCC doing a lot of work. Consumers experiencing vulnerability disadvantage, so it might be people from low socioeconomic backgrounds with poor language skills, elderly people, and so the ACCC is very focused on identifying cases where people in those categories are being taken advantage of. And finally, conduct impacting Indigenous Australians, and that's an area where the ACCC has done an enormous amount of work in the last few years. And unfortunately, a lot of scammers go out to remote communities and take advantage of Indigenous Australians. So that's an area that is a major focus. Now, moving on from the priorities, I guess it's important to understand those priorities and know that a lot of those priorities will actually probably benefit small businesses in terms of their impact. And so it's good to see the ACCC isn't just going after small businesses for breaching the law, but also helping them to run their businesses without unfair conduct. But the important thing to move to now is the penalties under the Competition and Consumer Act, and I've decided to put them in here rather than later on because it's just so important to understand how big the penalties are and the direction they're heading. So at the moment, the maximum corporate penalties are $10 million or 3 times the benefit, and if that can't be worked out, 10% of turnover. So effectively, if you're a small business, you're likely to be subject to a $10 million penalty for breaches of the competition and consumer law provisions. And these are the same penalties that apply to consumer law conduct. And as you can also see, maximum penalties for individuals are $500,000. Now, the scary thing is that the Albanese government has made a proposal and brought some legislation to Parliament to increase these amounts quite significantly. And as you can see there, they're proposing to increase the threshold amount from $10 million to $50 million, and further the turnover amount from 10% of turnover to 30% of turnover, and finally introduce this concept of turnover breach period. So let's have a look how that works. But the other significant change there obviously is to increase the personal penalties to a maximum of 2.5 million. So how's it going to work in practice? Well, the 30% threshold will sort of come in when a company hits $166 million turnover, around that number. So for any small business and any medium-sized business with a turnover of under 166 million, the $50 million threshold will apply. So if you look at the second example there, a small business, say a business with a turnover of $1 million, makes and gives effect to a cartel arrangement, that'll be 2 agreements times a make and times a give effect. So 2 times 2 times the threshold amount of 50 million, which would mean that that company would be looking at a maximum penalty for their conduct of $200 million. So then the courts are going to have to try and explain why a maximum penalty of $200 million should be reduced significantly down to a more sensible number. So as you can see, the proposed changes are going to introduce such huge penalties that it's going to be very difficult for courts to do anything but impose much higher penalties, and the big loser in this will probably be small business who get taken to court by the ACCC. Now, if you've got a turnover of over 167 million, then the 30% of turnover would apply, because you can see 30% of 167 is 50.1. So the way this is going to work is going to be quite remarkable. And I've just used $15 billion as a turnover, which is the turnover of Bunnings, and no suggestion that Bunnings has done anything wrong here, but just to demonstrate the point. Just assume Bunnings has made and given effect to 2 illegal agreements, and these agreements have been in place for 2 years. Then you'd have 2 times 4.5 billion for the 2 agreements that were made, and then you'd have 2 times the give effect times 2 years of turnover times 4.5 billion. So what you would actually end up, for the make, you'd have 9 billion, and for the 2 years of give effect, you'd end up with $18 billion. And that would result in a total penalty, a maximum penalty of $27 billion, which is a pretty insane number when you think about it, because suddenly you've got a $15 billion company that could be looking at a maximum fine of $27 billion. And I don't envy the role of the courts in trying to take a number of $27 billion and arrive at a sensible penalty from that starting point. It's going to be very difficult. Now, moving to the cartel provisions, the cartel requires a contract arrangement and understanding with the competitor. So as you can see, it can be a written document, but it doesn't have to be a formal written document. It could be arrangement or an understanding. So if you have a discussion with your competitor and you agree on increasing your prices, then you will be liable. They often say that a nod or a wink can constitute an understanding. So as long as there's some commitment by the other party or some assurance, then you have an agreement which could constitute a cartel provision. And that's very important, because if you go to a competitor, or a competitor comes to you and says, let's increase our prices, and you don't show any commitment or give any insurance, then no contract arrangement or understanding has been reached, and therefore you shouldn't be prosecuted. So it is a low standard. The fact that it doesn't have to be written and a nod and a wink could be sufficient means that it's not too hard to establish a cartel provision. Now, competitors can be other franchisees in the same franchise group. So the fact you're in the same franchise group doesn't mean it can't be price fixing. I said earlier, cartel conduct can be criminal for individuals, can be a penalty up to 10 years in jail, And the interesting thing is that, or important thing to understand, is cartel conduct is prohibited absolutely. So even if the particular agreement isn't going to have much of an impact on competition, it's still illegal and an offence. Now, the best way to understand the cartel provisions is they prohibit 4 types of conduct. Price fixing, so clearly agreeing on a price, or say removing a discount. They could be price fixing agreements. Also market sharing, so if you get together with a competitor and you agree on supplying a particular customer or supplying a particular territory, then that could be market sharing, and that would be a cartel provision. So it's a kind of conduct that you often see occurring where somebody says, well, this is my customer, you don't come after my customer, I won't come after your customer. That would be considered a cartel provision. Restrictions on output is probably the least likely to occur type of cartel provision, and the least likely to impact a small business, but it's when companies agree amongst themselves to produce less of a product for the market in order to push the prices up. So that doesn't happen necessarily that often, particularly in relation to small businesses. And then the final one is bid rigging. So small businesses getting together to agree to share out tenders for work, and there'll be an example of that coming up. Now there's a link there to the ACCC website. It's a very worthwhile place to go because it explains all the stuff about cartel prohibitions, but it also explains 2 things. Firstly, that there are immunities available for companies that are involved in cartel conduct, as long as they weren't the prime mover who started the cartel off in the first place. And so a person or a company that's involved in the cartel can seek immunity and avoid all punishment as long as they inform the ACCC and cooperate with the investigation. There's also a button there that you can press to anonymously report a person or a company that you believe is involved in cartel conduct. So it's well worthwhile going to that particular link and having a look at it. Now there's another resource which the ACCC put out a number of years ago called The Marker, and this is a very well presented video, dramatized video, which shows an individual getting involved in a cartel and how stressful that all gets, and then ultimately he decides to blow the whistle. And it is very realistic. It's based on a real case, so I'd strongly recommend you take the time to watch this video. It's about 16 minutes long, and it's very entertaining and very accurate. Now, just looking at a few examples of criminal cartels, just to really emphasize how they are operating. The first one was a country care case, and this was an interesting case because it involved assistive technology products. It's effectively products for elderly people or people with mobility problems. And the country care group was a sort of a buying group that worked together, a number of independent stores and this country care group that was over the top of the individual stores, and they had got together and put in a tender to supply the Department of Veterans Affairs with these particular products. And what had occurred was that the members of the country care group saw that a number of the individual stores were charging prices for products that were below the prices that were being offered to the DVA. And so that was a cause of concern because they obviously worried the DVA is going to get annoyed about not getting the best price in the market. So it was an attempt to get the members of the group to increase their prices, not to charge below the DVA price. And the ACCC commenced proceedings against the country care group, against the company and 2 individuals for criminal cartel conduct. Got through the committal stage, went to a trial. It was a very lengthy process getting there. The indictment had to be changed numerous times, and then the evidence was put to the jury, and as you can see, all defendants were found not guilty by a jury, and it was a unanimous verdict, and they only deliberated for 4 hours despite the complexity of the material put to them. So I think this is an important case because it can show how the ACCC investigates a case, and the DPP, who is responsible for prosecuting the case, can take a case against effectively a small business, and it can go on for many, many years, and ultimately they're acquitted. But the personal cost on the individuals in the company and on the company itself have been quite devastating. And that's the main thing to understand, that even if you win ultimately, if you're a small business, you get sued by the ACCC and by the DPP, it's going to really change everything in your business and in your life forever. And so it's very dramatic stuff. A case which is probably appears to be more appropriate in terms of the ACCC taking action, and this involved an alleged cartel between Deutsche, Citi and JP Morgan, with ANZ involved. And it related to an ANZ share offer where the Deutsche, Citi and JP Morgan were the underwriters, and the share offering was undersubscribed by, I think, $800 million worth of shares. So the underwriters had to pick up all those extra shares. And the allegation was they formed an agreement to progressively sell down their shareholdings so as not to, I guess, force the ANZ share price to go down dramatically, but also to, I guess, stop themselves losing quite a lot of money, because if you drop that many shares on the market, the price is obviously going to go down very quickly. And so the ACCC took legal action based on an immunity application from JP Morgan, who came in and spilt the beans about the agreement. But then we had this process where the case kicked around in the committal stage for a lengthy period of time. The DPP is trying to draft an indictment that is not defective. It keeps getting effectively knocked out, and they have to keep trying to draft an indictment that actually works. And more charges are dropped, agreements are dropped, defendants are dropped, and then ultimately the whole case is dropped in February this year. And there was an inability by the DPP to draft an indictment that would get over the line to go to a jury. Now, this has had a very profound effect on the individuals who were sued. So it was the three corporate entities there, but also quite a large number of individuals. It had a devastating effect on them. So this just highlights how complicated the legislation is, how difficult it is to really run a case, and I guess emphasizes the importance of being aware of what the law is and doing everything you can to avoid getting taken to court by the ACCC and by the DPP, because even, as I said with the earlier case, even if you're successful in beating the charges, it's going to have such a devastating effect on your life. This is another example which was recently resolved, and it was a criminal cartel case taken against a number of small businesses in the Vietnamese money transfer area. And the allegation was that a bunch of small businesses got together to agree not to offer their customers such high exchange rates, offer them lower exchange rates, and also to stop discounting the fees. And this was taken by the ACCC investigator, and then the DPP commenced proceedings, and the case went on for quite a while. And as the case was approaching trial, Vina Money, the main company involved, and four of the individuals decided to plead guilty. Interestingly, there was a fifth individual who decided not to plead guilty, and it was just about to go to trial, and then the DPP dropped the case against him, which seemed very strange to me why they would do that. So the court was faced with a number of guilty pleas. It decided to fine Vina Money $1 million, which didn't really matter because the company was in liquidation, so they didn't pay that. And then the court imposed individual sentences of imprisonment from 9 months all the way up to 2 years and 6 months, which is quite a big penalty with a maximum of $10 million, 10 years imprisonment. But the judge concluded that they should be given recognizance release or good behaviour bonds, so none of them ended up going to jail. So this is another case which shows just how small businesses could get dragged into a case and prosecuted, and no doubt the impact this is going to have on these individuals is going to be very significant. So I've done a case note, a video case note on this case, so if you're interested you can go have a look at that. Another recent example was a case against Bingo Industries and Daniel Tartak, and the allegation was that Bingo entered into this agreement with Aussie Skip Bins and Aussie Skips Recycling to increase the prices and fix the prices of skip bins for waste processing services in Sydney. This happened about 2019, allegedly, or not allegedly, they've all pleaded guilty now, but effectively the business was sold by Bingo to the Macquarie Group, and the Macquarie Group, when faced with the charges, pleaded guilty to them. So that just emphasises the point that if a new company buys a company that's engaged in illegal conduct, there's really often no skin off their nose just to admit the offences and move on. And Bingo's former managing director and CEO was also charged with criminal offences. He actually pleaded guilty to those charges today. So both Bingo and Mr. Tartak will be scheduled for a sentencing hearing probably in the beginning of 2023. Here's another case. This is a civil case, and this shows you how the immunity policy works. Delta was looking at putting in a bid for the National Gallery of Australia building management system, and the allegation was, because the case is still before the court, that an individual from Delta met with a competitor in a cafe to discuss bid rigging, and the person from the competitor must have blown the whistle on the whole attempted price fix, and as a result the ACCC commenced legal proceedings. So this just highlights the risks that small businesses could face. You have a conversation with the competitor and the other party could simply blow the whistle on you, avoid any liability for the conduct, and not only are you faced with a court case, but the likelihood is you're going to be excluded from this tender going forward, so you're going to miss out on the business and they'll be faced with a case against the ACCC. So a lot of risks with engaging in cartel conduct. Another recent example involved ARM Architecture, where the allegation was that the managing director of that company attempted to arrange a bid rigging cartel in relation to a project at Charles Darwin University, and the allegation is that he sent emails to 8 other architects who were competing for this particular tender, asking them not to submit a bid. And as a consequence, not only was a case taken against the company and himself, but Charles Darwin excluded ARM Architecture from the building project going forward. So that just shows the dual risks associated with cartel conduct, because not only will somebody probably blow the whistle on you and you'll get sued by the ACCC, but you'll be excluded from participating in the tender if there is one being offered. This is another example from a few years ago, and this involves what they call a hub and spoke cartel. So the allegation was that Woolworths were acting as the hub in a cartel agreement between Unilever, Cussons and Colgate, and effectively there was a concern amongst the three companies that when ultra concentrates were introduced to the market, the price would go down, as that had happened in other jurisdictions. So there was an agreement to try and ensure that prices didn't go down for ultra concentrates when they were entered into the market. Now, the interesting thing here is that Unilever looked at the conduct, believed it was a breach, and went in and blew the whistle on the other three. And then proceedings were commenced against the other three companies, and Colgate pretty much immediately just agreed to give up and paid a fine of $18 million. Woolworths also agreed to give up and paid $9 million. And then Cussons fought the case, and the case was dismissed against it. So this just shows a couple of issues. Firstly, small business have to be aware that sometimes there might be a third party who's willing to talk to other competitors to try and arrange some price fixing agreement, and that won't immunize you from liability. Often it might be an industry association or a consultant who says, I'll talk to everybody involved and get them to increase their prices. And sometimes businesses think that that means they won't be personally liable because they're not speaking to their competitor directly. But clearly, if there's this hub and spoke cartel, it's not going to be effective in avoiding liability. The other thing it shows is how circumstances can be quite complex, because clearly once Unilever had blown the whistle and Colgate and Woolworths pleaded out, you would have expected it would have been a lay down misere, that Customs would have been found to have breached the law, but that's not the way it worked out. So the law is very complicated in a number of respects. Here's another example, a civil case which involves a couple of small businesses, First Class and RAD. And effectively what happened here was First Class approached RAD about a tender for the Wesley College at Sydney University and said, First Class will put in a low tender, RAD will put in a high tender to ensure that First Class get the tender, and then for RAD's cooperation, First Class would pay $10,000. And then there was another tender, smaller tender, where RAD put in the lower tender, First Class put in a higher tender, and RAD won that amount and agreed to pay First Class $2,000. So this was very small companies tendering for the installation of slate roofs, and they got sued by the ACCC and they got fined a lot of money. First Class was fined $280,000. It needed 6 years to pay that back, and RAD Roofing was fined $65,000 and needed 18 months to pay that back, or to pay that to the Commonwealth. Now the important thing here to realise is that the maximum fines that these two companies were facing for this particular conduct was $40 million, because there was two agreements which they'd made and given effect to. So that was 4 contraventions with the threshold amount of $10 million. So the maximum penalty these companies were looking at on a corporate level, $40 million. So how the judge was able to reduce a $40 million maximum fine down to a $280,000 fine is a quite remarkable outcome. And that's going to be much more difficult in the future if these proposed changes come through and the threshold amounts increase to $50 million. Again, I've done a video explaining this particular case, so if you're interested in knowing more about it, go to my YouTube site and you can watch that video. Now, moving on to contracts, arrangement, understandings that restrict dealings or affect competition. This is your sort of garden variety section 45 case, and this really focuses on agreements that aren't between competitors. So this is where maybe two companies involved in a supply chain get together to try and stop competition from occurring, and really what the ACCC has to prove is that there's a purpose or likely effect of substantially lessening competition in a market. That's quite a difficult case to prove, because you've got to prove that there's a substantial lessening competition and you have to define a market. So these are the kinds of cases where it's unlikely that a small business would be a respondent to an ACCC case. Rather, it could be that you would be a victim of conduct engaged in by the parties. Now, I couldn't really find a lot of good examples to really explain this case, this provision, but this is a case that was taken not long ago where the ACCC alleged that there was this agreement whereby the Port of Newcastle, if it decided to establish a container port in its port, would have to pay a penalty amount to the Port, New South Wales Port, and that agreement was brought about by the actions of the New South Wales government when the port was privatised. So the ACCC alleged this was an anti-competitive agreement because it prevented the Port of Newcastle from proceeding with a container port, which clearly would have added competition to the market, given that New South Wales Port operates the container facilities down in Port Botany. But the case went to the judge, who was the judge who was recently appointed to the High Court, Justice Jaggett, who decided that firstly there was Crown immunity, so because the government was involved, New South Wales government was involved, it couldn't be held liable for this particular conduct. She also concluded that there was no anti-competitive purpose or effect, and so this big case that the ACCC spent lots of money on and ended up being thrown out by the judge entirely, and it's actually on appeal at the moment, so it'll be interesting to see whether the initial judge's decision is thrown out. But I guess a big focus here was that the ACCC looked at the benefits of competition in the Port of Newcastle for small businesses and other businesses located in that particular area, and concluded that there would have been significant advantages had the port capacity been able to be established. Here's another one from Queensland. This was ACCC and Cement Australia, and this just shows you the way that companies seek to prevent new entrants having access to vital raw materials. So here, Cement Australia obviously makes cement, and one of the products that it uses to do that is fly ash. And fly ash is actually a byproduct of the operation of power stations. So what Cement Australia did was enter into a range of agreements with power stations to prevent the supply of fly ash to their competitors. And the purpose and effect of that conduct was to prevent competition in the market by preventing an entrant from entering, which probably, when a lot of entrants come into markets, they're often small businesses and they want to grow to be bigger businesses. So you'll see large incumbents trying to enter into agreements to stop new players entering markets. So here the offence or the contravention was established, and Cement Australia and a number of associated companies were fined a total of $20.6 million. Here's another case which my team ran many years ago, and it says ACCC and Liquorland, but it's actually against Woolworths. Liquorland had already given up and paid a fine, and Woolworths decided to fight the case. But both Liquorland and Woolworths were entering into these agreements in the context of liquor licence applications, where they would insist on terms which would prevent the new entrant, which were invariably small businesses, from being able to establish a bottle shop and sell takeaway liquor. So what was happening was Liquorland and Woolworths, BWS, Porters, and all their different labels, Dan Murphy's, were seeking to protect their bottle shops from competition from new entrants to markets. And we ran the case purely as a purpose case. We didn't run the effect case. We just said the purpose of both Woolworths and Liquorland was to nip competition in the bud, and that was accepted by the judge, and total fines were imposed, which sound like a lot of money back then. It doesn't sound like much nowadays, but $11.5 million. This is another example of the way large companies can enter into agreements to stop small businesses from entering markets and growing their business and really competing on a level playing field. Another particular bit of conduct that's prohibited under the Act is called concerted practices, and this is where competitors seek to suggest what their pricing is going to be in the future with the hope that the competitor also follows the price increase. And I think I remember Amcor and Visy used to do this, and this was all before they were sprung for a cartel arrangement. But there'd be this process where one would issue a series of prices that was going to come into effect in 6 months' time, and then they'd sort of wait for Amcor to issue a similar price list reflecting similar price increases. And this was effectively price signalling, and it was engaged in for many years, and I think the companies took it in turns to release their forward pricing to their customers. So that conduct can actually be illegal under these particular laws. It's described as a concerted practice relates to coordination between competitors without a contract arrangement or understanding. It covers direct and indirect contact between competitors, and the object or effect is to try and influence your competitor to go a certain way in relation to pricing by putting something out in the market publicly. So you're ostensibly telling your customer what the price is going to be, but really what you're trying to do is tell your competitor where you're headed with price so that they react in a similar way. So another thing that the banks used to do when they used to foreshadow how much of a Reserve Bank increase in interest rates or decrease in interest rates they were going to reflect in their particular interest rates for borrowers. Now, there hasn't been any court cases on this particular provision, but there was one example, and again involved small business, and it followed the Sydney hailstorms a few years ago, where a number of small businesses decided to communicate on social media about the opportunity this presented for them to increase prices. So as you can see there's a quote, "I think the latest storm is a perfect opportunity for the roofers of Sydney to increase pricing across the board as a standard that doesn't decrease." So there is floating the idea of this is a great time to increase our pricing. And then another person responded, or another business responded, "Let's agree that we start from 65 and go up." Now there was no response to that particular message, but obviously there's a telegraphing of a price that really competitors should aim to charge in the market. So this was considered a concerted practice. Fortunately for the small businesses, the ACCC let them go without any penalties, with a warning. Now just moving on to section 47, which is exclusive dealing, and this is really a series of very complicated provisions which relate to the supply of goods or services on a condition which limits another party's ability to choose the customers or suppliers, where it operates, and the terms on which it conducts its business. So effectively one company might say, "I'll supply you goods on condition that you don't supply these goods in a particular area," or "I'll acquire goods from you as long as you agree not to acquire goods from my competitor." So there's a range of different ways that this can manifest itself, and the key thing to realize here is often the big company requiring a smaller company to limit their acquisition or supply of goods and services to potentially get at a competitor, not so much directly but sort of indirectly. Now these particular types of conduct are only illegal where they substantially lessen competition in a market. So where they're just going to have a negligible effect on competition, they're not illegal. There was something called third line forcing, which was a prohibition which said if somebody supplies a good to another company on condition that they acquire goods from a third party, that was against the law as a per se offence, but now that's also subject to a competition test. And often there's a lot of exclusive dealing which isn't going to lessen competition, which is notified to the ACCC. So companies will let the ACCC know, advise them of some exclusive dealing, and the ACCC will effectively, if they have a concern with it, they'll raise a concern, but otherwise they won't raise a concern, and that means the conduct is approved by the ACCC and nobody can get sued for it. Now here's some examples just to explain the way it works. So a recent case was Peter's Ice Cream, which basically went to its distributor, PFD, and said that we won't buy distribution services from you if you agree to sell our competitors' single-serve ice cream products in particular geographic areas. So what it was seeking to do was to pressure PFD to choose Peter's over its competitors. And here you can see PFD required the prior written consent of Peter's Ice Cream before they could supply these competitor products into particular geographic areas. And obviously the losers there is not only Peter's competitors, but also the small businesses who are trying to sell single-serve ice cream and have a much narrower range of products. So as you can see, exclusive dealing is not intended to hurt the small businesses, but they're sort of collateral damage in a sense. So this was a case that resulted in Peters being fined $12 million. Here's another example of my team around this many years ago. And this is a case where Fila, a large company, implemented this selective distribution policy where it would only supply its AFL licensed merchandise, which was the really flash, expensive type of apparel, to retailers on the condition that they didn't sell the AFL licensed apparel of another company, which was a small business, in their stores. So obviously that was conduct which adversely impacted the competitor, but also damaged a number of small business retailers who wanted to be able to offer the expensive, flashy AFL merchandise, but also the cheaper, probably more mum and dad type of merchandise as well. So this was a case where you can see exclusive dealing aimed at hurting a competitor, which in this case was a small business, but also had a negative impact on a number of small business retailers. And we got a penalty of $3 million, which again seemed like a lot of money back then. It seems pretty small amount now. Another example is that the Australian government decided to change the law on parallel importation of CDs, and in the past you couldn't import CDs from other countries, but that was removed, and so you had a lot of small Australian retailers seeking to import CDs from other countries, particularly Indonesia, and selling them in Australia and making bigger margins. And the various recording companies didn't like this change at all, and so what they did, they tried to subvert the legislative change by basically saying to these retailers that if they wanted special artists who were particularly popular in Australia, as well as the back catalogue of older artists, that they would only get those if they agreed not to parallel import. So again, here's small business retailers seeking to make some money by parallel importing, taking advantage of a government legislative change and being pressured by very large companies to not take advantage of these changes and not to sell these parallel imported CDs. And they were fined $2 million for that conduct, which I think at the time everybody sort of thought the judge maybe had forgotten to type in an extra zero there. Now just moving to the boycott provision. So with the restricted trade practices, as you can see, it's good to understand those particular laws, because often you may be the victim of illegal conduct by the larger companies. Now the boycott provisions, there's as you can see, 4 provisions there, and there's secondary boycotts, and also 45E, which is sort of the reverse of a boycott. It has the same impact, but now looking at 45D, it's a complex provision, and effectively it's where a person acts in concert with a second person to hinder or prevent a third party from supplying or acquiring goods or services with the purpose and effect or likely effect of causing substantial loss or damage. That's quite a mouthful. A lot has to be proven. But the key thing here is that usually one union acts in concert with a second union to try and hurt a third party, which is usually a business. And that's often because the third party might be using non-union labour or may have not agreed to some union demand. And as you can see, it's hard to prove because you've got to prove two things, purpose and effect, not just purpose or effect, and you also got to prove that it's going to cause substantial loss or damage. There's another provision, DA, which is exactly the same as D, but this is where the conduct substantially lessens competition in a market, and the penalties for that can be very large. The penalties for boycotts are about $750,000. They haven't been increased to the same level as the penalties for businesses, which is somewhat surprising. But this particular provision is subject to a $10 million penalty. No case has been run under 45DA. Now a good example would be the CFMEU case, which is probably the major boycott union in Australia, and they ran some secondary boycotts against Boral and Allsafe at various construction sites, and it was a concert with a shop steward, and they were hindering or preventing the acquisition of concrete. I think they were stopping trucks from getting onto the sites to take concrete away. So that's the way it works. They had a dispute with Boral and Allsafe in relation to probably some union issue, and they were taking action with the shop steward to prevent trucks accessing the site and taking away concrete. Now they were fined $500,000 for each of the 2 contraventions. So $500,000 is the biggest penalty under the secondary boycott provisions for 45D conduct, and that remains the case. There have been some bigger penalties for other provisions, but that's the biggest penalty for 45D. Now the other provision is the sort of the trade and commerce, international trade and commerce power, and this is one that prevents unions effectively from stopping the movement of goods either through the ports to places overseas or via airlines. So a person has to act in concert with a second person for the purpose and effect or likely effect of preventing or substantially hindering a third person, and that can often be a shipping company, it could be a trucker taking a container to the ports, it could be a plane taking a freight train, a plane taking product overseas, to engage in trade and commerce in the movement of goods between Australia and places outside Australia. So a good example is the case I was involved in at the ACCC against the Maritime Union in relation to hull cleaning. And effectively here, the Maritime Union, who used to be known as the Painters and Dockers Union, used to like cleaning the holds, which is inside of bulk ships, cleaning the holes out. And what was happening is companies didn't really like using the Maritime Union, so they're hiring private cleaners. And what the Maritime Union did was they unlawfully hindered and prevented vessel sailing unless the ship owner charterer agreed to hire the Maritime Union to clean out the holes. And when people didn't agree, there'd be unlawful action to stop the vessel sailing. So often people would come down, and when the ropes were to be let go off the bollard to release the vessel, some guy would just sit on that and prevent the lines being released, and the vessel would miss its sailing window and have to remain there till the next day till it could sail. And these vessels were often chartered at $40,000 a day. So you can imagine you do that 2 or 3 days and suddenly the ship owners lost a lot of money. So we took the case on 45DB because it was obviously preventing goods from being moved from Australia to places outside Australia. We also took an undue harassment Section 60 case, and we were successful on both of those cases. The union paid a fine of $150,000, which is pretty good really from a union, and it's the first time that a penalty was ever imposed for a breach of 45DB. Now, another case that's probably instructive was a case I worked on at the ACCC, which was a waterfront dispute cases. And this happened when Chris Corrigan sacked his Maritime Union workforce, everybody remembers that pretty well, and brought in non-union labour. And the union responded by announcing this global boycott of any vessel that decided to use non-union labour. So we took them to court and we got injunctions against the Maritime Union, a number of people from the union and a representative of the ITF, preventing them from taking any boycott action against ships loaded or unloaded in Australia using non-MUA labour. And there was a lot of boycott conduct happening at P&O terminals in Newcastle and Adelaide. It also threatened boycotts against a number of shipping lines. And so we got the injunctions and we prevented them from continuing the boycott. Ultimately, the case was settled with the Maritime Union, provided us with some undertakings, and we actually got a trust fund set up. And it was, ironically, it was funded by Patrick Stevedores, but the purpose of the trust fund was to compensate primarily small businesses who'd been adversely affected by this conduct, by this big fight between the Maritime Union and Patrick Stevedores. So again, folks at ACCC was to help small businesses there. So I guess this shows how small businesses are often the victim of these industrial disputes, whether they be truck drivers or small businesses seeking to export product. They're sort of the collateral damage. And ACCC, I think, does a good job in trying to protect small businesses from illegal conduct such as this. Then there's 45E, which is a different type of provision. It's when a particular company enters into an agreement with a union, usually to achieve some industrial peace. And as you can see, the first person makes agreement with the union for the purpose, and its only purpose here, which is somewhat surprising, of preventing or hindering the first person from supplying or acquiring goods or services. So an example probably explains this very well. It's the recent case against Hutchinson. So what happened is this waterproofing company was hired by Hutchinson to do some subcontracting work. It did not have a enterprise bargaining agreement with the CFMEU, which annoyed the CFMEU, complained about it, and then communicated to Hutchinson that there'd be industrial action if Hutchinson allowed this particular company to continue operating. Hutchinson responded by excluding the company from the site, and ultimately its subcontract was terminated. So this is Hutchinson coming to agreement with the CFMEU to kick out a third party who was pretty well a small business, because they didn't want to get or to be the victim of industrial action. So again, you can see how these agreements could damage small businesses, collateral damage, but it's also the kind of thing a small business could be tempted into doing with the union to avoid damage to their own business. In this particular case, CFMEU was, and it became the MEU with the merger with the Maritime Union, was fined $750,000, which is the maximum penalty available, and Hutchinson was fined $300,000 for 2 breaches, which led to a total penalty of $600,000. Now, moving to misuse of market power, this provision has changed over the last few years, and it requires a company with a substantial degree of market power who uses, well, doesn't actually have to use the power. They have to have a substantial degree of market power, and they engage in conduct with the purpose or effect, or likely effect, of substantially lessening competition in a market. And one issue that was removed in the current law that exists in the previous law is the causal connection between the company's market power and the conduct they're engaged in. So the concern was that this was going to make it a bit too easy for the ACCC to take action. That really hasn't occurred, mainly due to the requirement to prove substantial lessening competition. Now, the recent example of this is a case that the ACCC took against MasterCard, and this is before the court, so nothing's been determined. But effectively, the ACCC alleged that MasterCard used its market power to try and substantially lessen competition in the market for the supply of debit card services. And what had occurred was the Reserve Bank had brought in these rules about least cost routing. And effectively, it was to give consumers the benefit of the cheapest payment method when they were buying products. And so what MasterCard allegedly did was entered into agreements with 20 very large retailers, saying to them that we'll give you discounted rates for MasterCard credit card transactions if you commit to processing all or most of your EFTPOS debit card transactions through MasterCard. So it was using its market power to give these major retailers a financial benefit if they funneled all these other transactions through MasterCard, and obviously that's to defeat competition in the market. It's also conduct which is probably going to ultimately filter down to smaller businesses, start with 20 major retail businesses and then make this obligation on smaller businesses. And so the ACCC has taken action at an early stage and obviously stopped the rollout of this particular plan. But ultimately this conduct was likely, if not picked up by the ACCC, to damage small business in the longer run. This is another case, misuse of market power, which I think involved a small business. Ultimately, there was a new player entering into the market in Tasmania to provide various towage services, and the way Tasports, the sort of monopoly operator of the port, responded was to introduce new charges for the customer who the competitor had secured as their first customer. So it was trying to disadvantage the new entrant to the market by increasing charges. And ultimately the ACCC didn't impose a fine here. It decided to adopt a remedy that was going to generate more competition in the port, which would obviously benefit users. So it was a very pragmatic outcome, but clearly focusing on improving competition rather than trying to get a big fine out of Tasports. This is another case a few years ago where Basic Cab Charge had a very strong position in relation to processing payment products through various cabs, and there was talk of new entrants to that particular market, and they weren't small businesses, I think it was the large banks, and obviously Cab Charge didn't want to allow these new competing suppliers into the market, so they did a range of things to exclude them, including providing below cost taximeters to various cab drivers. So it was very clear conduct in order to prevent competition in the market. And I guess the main thing here is if you've got a bigger variety of payment products, then that competition is going to benefit the small business operators in the market, the cab drivers, and by seeking to forestall that, there is some further collateral damage to small business. Ultimately, they were fined $14 million for this conduct. Ticketek, again, there was a new entrant coming in to challenge Ticketek's strong position in the market, Last Ticks, and they tended to try and supply these last-minute discounted tickets. So that was obviously good for consumers. And what Ticketek sought to do was to interfere with the various events which Last Ticks was promoting tickets for. And again, Last Ticks probably wasn't a small business, but it was a smaller competitor seeking to get a foothold in the market, and Ticketek used its market power to prevent them from succeeding. So as you can see, there's a bit of a theme in these cases. It's often an incumbent trying to implement some method to prevent a new player from getting in the market and establishing their position, and often small businesses, and I just keep going back to this theme, are the collateral damage to this conduct. In this particular case, Ticketek was fined $2 million, which again was probably missing a zero. Now, something that small businesses really have to be aware of is resale price maintenance. There's a lot of it occurring, and this is where a supplier prevents a reseller of goods from selling their goods or services below a specified minimum price. So this is where companies don't really want discounting to occur for a variety of reasons, but often they might have a brand reputation which they want to maintain, so they want to keep prices up, but also there might be competitors who have higher costs, who want to sell products at higher prices, and if there's a lower cost small business selling products at discounted levels, that creating a lot of difficulty in the market. So you often see suppliers pressuring discounters to stop discounting or to sell at recommended retail prices. And also there are a couple of deeming provisions which are interesting. So if a company has a reputation discounter in a period of 12 months and then they have their supply cut, then the legislation actually presumes that there was resale price maintenance going on. That was the reason their supply was cut. There's also a loss leader exception. So if a retailer is actually using the supplier's products as a loss leaders in the business, then the supplier is entitled to cease supply to that customer. So some examples, the FE Sports is probably the most recent one, where FE Sports sold cycling and sporting products, and they entered into lots of agreements, primarily with small businesses, prohibiting them from selling below the RRP. And the interesting thing about this case was ACCC warned FE Sports numerous times to stop engaging in RPM, and they didn't take any notice. And so ultimately the ACCC took legal action and got a penalty of $350,000. So again, you can see that a lot of small businesses are probably being forced to sell products at a RRP, which was likely to result in them receiving less sales. Another example is Hugo Boss, which is one of these brands that had a very strong brand reputation, and they had a systematic pattern of going around and requiring their retailers to sell at particular prices, and if they weren't in agreement to selling at those particular prices, they would cease getting supply. So again, this is a case that was impacting small businesses who wanted to sort of maybe discount the Boss suits to get people in the store and then to maybe sell something else to them. But that's illegal, it lessens competition, and they were fined $515,000 for that conduct. So finally, I'll look at the prohibitions of acquisitions that result in substantial loss in competition. And this is relevant to small business because often there might be a merger in your particular industry which you're concerned about, which will lessen competition. And what you should be aware of is that you can actually make submissions to the ACCC to explain why you're concerned about a merger, and they will take those submissions seriously. So if there's an acquisition of shares or assets which has the effect or likely effect of substantially less in competition, the ACCC can prohibit it. So there are a number of proposed changes which the ACCC has raised to try and improve the laws. So it's not too clear whether the government's going to be interested in these proposed changes. Just looking at a couple of examples, there was the Wattle Taubens case, which my team ran many years ago, and this was a proposal by Wattle to acquire Taubens, and we were concerned, the ACCC, that if Taubens and Wattle got together, they'd have a similar market share to Dulux. So the two providers of paint, architectural and decorative paint, would have a very similar market share. So we thought there was a risk that they might collude, and this case was quite criticised at the time, but it was based largely on feedback from small businesses in the market who were very concerned about having the options which they had for the supply of paint reduced. So we took legal proceedings against the companies and prepared a very good injunction case, and then the companies consented to the injunctions. That was in March 1996, and then they applied for authorisation, which we did reject in May 1996, and then the case before the Australian Competition Tribunal was proceeding, and the merger was ultimately abandoned when Taubens sold the business to Plascon, who has been running it ever since. So this is just an example of the way that small businesses can have quite a big impact on whether mergers go ahead by lodging complaints with the ACCC, and I guess also being willing to provide evidence if it comes down to a trial. Another case that I worked on back at the ACCC was the British American Tobacco Rothmans International Global merger, and obviously in Australia it had a particularly profound effect given the market shares of the two companies, and we opposed it in March 1999 because we thought it was going to substantially lessen competition in the Australian cigarettes market. We thought that the market had very high barriers to entry, that new entry was very unlikely, and also there was no import competition, and the merged group post acquisition would have had 62% share of the total market, but 96% of the premium cigarette segment and 61% of the value segment. So we thought it was going to let lessen competition, and we made it clear what our views were, and they came forward with a divestiture proposal to sell a suite of assets to Imperial Tobacco, which is a big company in its own right. And it was interesting, the divestiture package included brands in each of the three categories: premium, mainstream and value, but also distribution and manufacturing. So it was a total package which Imperial Tobacco could buy and more or less turn a key and start competing in the market the next day. So it was a very comprehensive divestiture package. I think it was about a third of the total value of the merger. $325 million worth of assets were divested. So this is another case where small businesses were concerned about the impact of the merger, were complaining to the ACCC, and that was a fairly significant part of the reasoning of the ACCC in opposing this merger. I must admit at the time I was wondering whether it might be good to let the merger go through so that cigarette prices would increase and our health would improve, but that isn't consistent with economic theory. And this is another interesting case which I worked on at the ACCC, and this was when Smorgon bought A&I Industries, and this was in the national market for the manufacture and supply of reinforcement bar, and we thought it was going to substantially lessen competition, primarily because there was a proposal to change the Australian standard for reinforcement bar so that it was consistent with the TEMCOR patent. Now the interesting thing here was the TEMCOR patent was owned by Smorgon, who for some reason decided to sub-license it to BHP, its major competitor. So the only two companies in Australia which had the TEMCOR patent were Smorgon and BHP, who also had a lot of representatives on the relevant standards committee. So we were a bit concerned that maybe they would vote to change the standard to make it consistent with the TEMCOR patent, and therefore they'd be the only two companies able to supply a reinforcement bar in Australia. So what we did was we got an Section 87B undertaking from Smorgon, which prevented or required them to abstain from voting on the proposed Australian standard for a reinforcement bar until either their TEMCOR patent expired or we said it was okay to do it. And as it turned out, they didn't vote until after the TEMCOR patent expired. Now this is another case where the people who told us about this conduct were small businesses who we interviewed as part of the investigation. They explained to us about the temp core patent, the implications if it became the Australian standard, who owned the patent, and all the rest of it. So here, small businesses were again very instrumental in assisting us to understand the industry and to take what was very effective action to prevent a duopoly from developing in reinforcement bar. So just moving to the ACCC powers, and I'll go through this relatively quickly. The ACCC has the power to issue what are called Section 155 notices, which are effectively like subpoenas, and they can force small businesses to provide documents, information and oral evidence. And often these notices have very short time frames to respond, require an extremely large amount of information. So if you get a notice, probably the first thing is to get a lawyer to assist you in understanding the notice, but also don't panic. The ACCC is quite open to staging the production of documents and information to them. They understand that people can struggle to get this information together quickly. The other thing that the ACCC can do is bring in individuals and effectively cross-examine them under oath for information. Now, I don't have a video of a Section 155 oral examination, but probably a good example of the way it works is this video of Bill Gates being deposed in the Microsoft case from many years ago. And this is pretty much the way it works, the questioning, the requirement to answer questions. I think one thing it's fair to say that Bill didn't do very well in this deposition. I think you watch the video, which I strongly recommend, you'll see how he doesn't really answer the questions very quickly, or it appears very candidly. Now, other powers that the ACCC have, they have a power to execute search warrants in relation to both competition and consumer law matters. They tend to use that power sparingly, or actually not at all in the last few years during COVID, but prior to that fairly sparingly. But now COVID's, we think, has passed, chances are they're going to start using that power much more. It's a very intimidating experience. I've done a video on the YouTube channel which explains the law around this and the way it all works. So if you are interested in that area, have a look at that video. Also, they can do telephone interceptions, listening devices in relation to cartel conduct, and they use the Australian Federal Police to go and do that. So the thing to realise is they can actually bug your phones and plant listening devices if they're investigating cartel conduct. Now, there's another video here which I'd strongly recommend you have a look at, and this is, as people may know, the Informer movie. Well, this is the real life lysine cartel that formed the base of that movie, and this is actually a hidden camera that the FBI have placed in a television set in a room where cartel meetings occurring between the executives of the lysine industry, and it just shows you how sophisticated their technology is and how these powers that now the ACCC has can be used to get very probative evidence of breaches of legislation. And this is many, many years ago, so you just imagine nowadays how much better the technology is. So strongly recommend you watch that video. It's not very long. Here's another YouTube video which is actually a transcription and the audio of a tape recording made, I think a telephone interception made of a further communication between representatives of the lysine cartel in in the US and Japan. So this gives you a good indication of how the phones can be intercepted, phone calls can be intercepted, and the probative evidence that can be obtained nowadays by the ACCC, but this is being obtained by the FBI like 20 years ago, 30 years ago. Now, I said earlier the penalties for breaches of both the competition law and consumer law are likely to go up. Legislation has been put to Parliament, and this is going to have a very profound effect on the way cases are run going forward. So I won't go over that again, but that's a big concern. The ACCC can also get other court remedies. They can get declaration, or they invariably seek a declaration, which is a statement from the court that your business has broken the law, injunctions to stop you from engaging in the conduct again. But a very serious order they can get is a disqualification order, which is to prevent a person from being a director or manager of a business for a period of time. And they'll often seek that, and that's a very damaging remedy, particularly for a small business owner who may be prevented from running their business or even operating the same industry for a number of years. The ACCC can also see non-punitive orders, which is a court-ordered notice or advertisement to correct a misrepresentation or provide information. The best example is that slate roofing case I mentioned before, where the respondents were required, the small business were required to prepare a notice explaining what they'd done, the consequence of what they'd done, and the implications for them of their conduct, and for that communication to be sent out to all the members of the New South Wales Roofing Association to educate them about the cartel provisions in the legislation. So that's the kind of order the ACCC can seek. Adverse publicity orders are also a remedy that can be sought by the ACCC, and this forces a business to admit that they break the law. They're not very common, but I recall recently the ACCC sought one against the CFMMEU, who simply consented to an adverse publicity order, which is sort of surprising. It's also important to understand that the indemnification laws under both the Australian Consumer Law and the Competition and Consumer Act, and effectively it is now illegal for a business to indemnify its officers for a breach of both the CCA and the ACL. So what that means is that if the ACCC sues your business, your company, and you personally for breaching the legislation, your business can't pay for a lawyer for you, nor can your business pay the penalty for a breach of the legislation. So you're on your own. You've got to find the money to hire a lawyer for yourself and to pay the fine. I remember I once represented a client who got a personal penalty. He gave me the penalty to send to the ACCC, and he wrote a check, and I said, you can't give me that check, that's from on your company's checkbook. So this is a very significant change which applies in Australia. It doesn't apply to some other jurisdictions, but applies here. And what it tends to do is tends to force individuals to try to find the money to fight the case. And if they can't find the money to fight the case, they end up giving up and consenting to all the orders. So you really got to look as a small business, maybe some sort of insurance arrangement at a personal level so that you are covered for legal costs arising from an ACCC investigation and litigation. Now I've got a few other videos of interest on my YouTube site that you might want to watch. There's the 10 biggest mistakes that companies make when dealing with ACCC, and that's quite worthwhile, I think, to look at that. As I mentioned earlier, the ACCC search warrants presentation. There's one about ACCC compliance programs. Also did one on greenwashing that explains all the cases that ACCC took in relation to greenwashing over the last few years, and also the types of things you've got to look out for when making environmental claims. I also did a case note on ACCC and Fuji business innovation, which is actually about the unfair contract term laws as they exist currently and the proposed amendments to those laws. And finally, the last video is called Up, Up and Away, the proposed increases to the competition and consumer law penalties. That's one where I go through the changes that have been proposed to increase pecuniary penalties. Now I've got to get the last slide quickly so these videos don't all play.
Hello, my name is Bob.
I'm sorry about that, but that's just one of the implications of having all these videos. The final thing is that if you have any questions about anything in this presentation, which is now an hour and 40 minutes long, feel free to either put a question on my YouTube site, and I'm quite diligent in looking at those questions and answering them, or alternatively you could email me or give me a call. And if you do want a copy of the PowerPoint presentation with all the active links in it, feel free to look at my blog or email me and have a look at it. So hopefully this has been helpful. I think small businesses really need to be aware of the competition law provisions and where they could potentially get in trouble, but also where they might be a victim to illegal conduct, and they really should complain about illegal conduct like RPM, exclusive dealing, to the ACCC, and I think particularly participate in mergers and acquisitions which will adversely impact their ability to compete in markets. You really should be going to the ACCC and explaining your concerns, and the ACCC will put weight on those concerns. So you've got to look after your own interests by approaching the ACCC. So that's all I got for this particular presentation. I'll probably do another one in relation to the Australian consumer law in the next couple of months, but that's all for me now, and thanks for listening. Bye-bye.